We had a guest here yesterday who gave us a rough estimate of what all those buildings might be costing.
Yes.
And he said all of them total might be like 2.3 billion. That's what he said. Now, we also had one of our viewers sent in some comments as regards the cost of buildings in Gombe.
Yes.
And they said you could get a 3-bedroom flat for as low as 15 million.
Yes.
Now, let's just assume that he has 10 3-bedroom flats. That's about 150 million.
Yes.
Coupled with, and the amount is 23.3 billion.
Yes.
If you put all of that together, do you think it's commensurate?
Well, you ask me this question is tough, but you see, you put all of these things together, you know, it's speculative. How much all these buildings will cost? Probably has some in Abuja too, because if you are talking of the
depends on the location in Abuja.
Yeah.
It depends on
the
location.
It depends on the location. But somebody who has stolen that much would not go to Gwagwalada to build houses. I mean, he must have chosen choice areas to build this thing. But that's immaterial. You see, the judge takes so many. When the judge sits down to take a look at things, he does not say, okay, I'm going for the kill. No, he wouldn't do that. He has taken a look at the various properties recovered. And don't forget, there was a plea bargaining element in the whole thing. Plea bargaining means, this person has admitted to having committed the offense or the offenses, and therefore, relieves us of problems. We are not going to, the costs of trials, the prolonged trials, and so on, that is not there anymore. And the nature of plea bargaining is that once you've admitted to any offense, and the trial terminates, then the judge will, you pleaded extenuating circumstances for yourself. So the judge will take all those into consideration in giving a sentence.
Okay.
Yes. But the major thing, as far as I'm concerned, is that the man has been convicted. Now, henceforth, the man is known as a convict, an ex-convict, if he's going to get out of the hook, the present one that he is into. Now, much of the time, you discover that all the tribunals and the high courts and the federal high courts and so on don't do what Justice Tarba has done. You know, what we want to see is bring these people to trial, try them, send them to jail, where they are found guilty, so that we can know that yes, this person has done this and he's been sentenced. He's been convicted and sentenced to jail, and then it will serve as a deterrent to other people. No, people have not been doing this. That he has done this one, just like Justice Gabriel Kolawole did a few weeks ago. In sentencing a few days ago, in sentencing the bombs of October 1, 2010.
Okay.
The Eriwari, or what's the name?
Ebiwari.
All right. He did that. You see, he took that straight from Section 40 of the Criminal Code Act, Cap 77 Laws of the Federation of Nigeria, 1990. Now, Section 40 says, anybody that is guilty of this thing or is either is a principal offender or is an accessory after the fact shall be guilty of an offense and shall on conviction be sentenced to life imprisonment. And he did just that. Okay. That's what the law says, and he did that. So,
but since they all say that justice must not just be done but must be seen to have been done.
Yeah, that's right.
Yes, he's an ex-convict. But you have people in society who say, look, they don't think, just as he said, this is not commensurate, because they say you've seen ex-convicts go about their normal businesses as though nothing was wrong. And so to that extent, shouldn't the law be mindful of the fact that there ought to be a lot more punitive steps taken to ensure that the society actually sees that justice is seen to have been done in order to serve as the deterrent which you talked about?
Yes. Now, that beautiful question. But I think I've answered it too, because you see, the law, we will now point an accusing finger at one direction, and that direction is the law, where the law is. It is the law. You ask me whether shouldn't the law take into account, I mean, that for justice to be seen to have been done, the law should be more punitive than it is today. Yes, I answered that question in the affirmative.
Yeah, but the judicial discretion, is not like
that. Yes,
which the judicial discretion.
Yes, judicial discretion doesn't mean that you jump completely outside the realm of the law.
But why does the law in the first place even allows that?
Yes.
Why does the law allow that in the first place?
Correct.
Because yesterday we were asking Mr. Keyamo if we have different laws for different categories of persons. Because you've seen a man, maybe he went into a yam barn, stole a tuber of yam.
Yes.
He gets a stiffer penalty.
Yes.
But now here we are with this scenario, and we had to put that in the law and pretend it's not just there.
Yes.
Possibly, maybe, because we understand that the man who will be under that particular law in the end will be someone very big in the society.
Yes. You see, the law seems to be like that today. And that's why we are advocating, or we should advocate, a drastic review of the laws. I mean, like you have just said, if somebody steals a ewe, a calf, a goat, a sheep, whatever, now he goes in for at least 2 years. Now, and then here is somebody who has stolen and has admitted to having stolen 23.3 billion naira, going in for 2 years at the same time. So you are correct that the law would seem to favor big-time thieves rather than the small ones. When you steal small, you go in for big. If you steal big, then you go in for small. That is what the law is, and that's why we are saying the laws have to be reviewed. Unless and until they are reviewed, then the judges have no alternative but to interpret the laws de lege lata. Interpret the laws the way they are. You don't expect them to jump completely out of the law, all in the name of judicial activism. There is an extent to which you can pander to judicial activism, beyond which you will be a rascally judge. I mean, nobody will take that because the law is clear. Where they say you can extend the sentence to 2 years, meaning like you said, it could just be 6 months. It could just be 1 year. It could just be 1.5 years, provided it is no more than 2 years. That's what the law is saying. And he gave the maximum sentence in this case. And then when you talk of, this thing, it took into consideration the fact that the man did, what's the name, free bargain, plea bargain. Yes.
Part of what members of society see, they say that, for instance, now lawyers they know the law.
Yes.
They are the practitioners. They see this since day in, day out.
Yes.
And that they didn't even know this penal code before these judgments came through.
Yes.
Would it be out of place for members of the bench, or even the bar, or either of them, to have come forward and suggest to society that this needs to be amended from the look of things?
Yes.
Now, has that happened, or perhaps have we missed it? Because before this judgment came to light, this law has always been there. Yes,
it has always been there. And don't even forget that this penal code we are talking about was enacted in 1916.
Wow.
You see, so, and it continues like that, and that was just a few years after the amalgamation of Nigeria. And it's still there. And the lawmakers know this. With the, corruption skyrocketing, they ought to know that all those fines and sentences of, say, 6 months or 1 year or 2 years, and then, fines of, 200 naira, 150 naira. Because in those days, what mattered to our colonial masters during the British colonial times was terrorism, not corruption. Because blacks were not there anyway. They were the people who were there. So they wouldn't talk of corruption and then say corruption cases must attract this much. You see? So now that the case is like this and corruption has become systemic, it's become baneful, it's become the poison in our own socio-economic development, our own lawmakers over the years ought to have seen this.